Blessings, comrades of truth. Mayest we have a continuation of the reading of a book. Not this book, although maybe more beneficial. The primary trust issuing your rights. Thank you, Lord. But this book, The Law of War and Peace. So we're on chapter 1, because last time we read the preface. Let's see. Well, we'll have to adjust the light as we go, but that should be fine for now. Here we are. Book 1, rather. What is war? What is law? The disputes. Number 1. The disputes that arise between those who are not held together by a common bond of civil law, such as a people who have not yet combined to form a nation, are connected either with times of war or with times of peace. So, too, are the disputes of persons who belong to different nations, whether they are private individuals, or kings, or persons invested with ruling power, such as an aristocracy, or as the body of a free people. So, because war is waged for the sake of peace, and there is no dispute which may not give rise to war, it will be proper, in a discussion of the law of war, to treat every kind of quarrel that is apt to arise, and then war itself will lead us to peace as to its rightful end. Number 2, in treating of the law of war, the first point we have to consider is, what is the war, which is the subject of our inquiry, and what is the law which we seek to establish? Cicero called war a contest of force, but the custom has been to indicate by that word not an act, but a state of affairs, so that war is the state of forcibly contending parties, considered as such. This general definition comprises all the wars of every description that will form the subject of the present treatise, nor are private wars excluded from this definition. Private wars, what is that? For in fact, they came before public wars, and are private came before public. Therefore, it has higher jurisdiction. For in fact, and it's a fact, settled matter, they came before public wars, and are undoubtedly of the same nature. They should therefore be included under one of the same term. I do not mention justice in my definition of war, because the very point we are to decide is whether any war can be just, and what kind of war is actually so. Therefore, we must make a distinction between war itself and the justice of it. Number 3, as the law of war is the title we give to this treatise, our first inquiry, as I have already stated, is whether any war can be lawful, and, in the next place, what is lawful in war. War here signifies nothing but what is just, and that more in a negative than in a positive sense, so that a lawful thing is what is not unjust. So that a lawful thing is what is not unjust. Now, anything is unjust which is opposed to the nature of a rational society, Thus, for instance, Cicero says, to deprive another of what belongs to him for one's own advantage is against nature. And by way of proof, he adds that if the practice were general, not special, all society and intercourse among men would necessarily be destroyed. Seneca, too, remarks that, just as all the members of a body agree among themselves, because the preservation of each is to the interest of the whole, so men refrain from injuring one another. For we are born for society, which cannot be secure except by giving love and protection to its parts. There is one kind of social tie founded on equality, as, for instance, that between brothers, citizens, friends, and allies, and another kind of preeminence, as Aristotle styles it, such as that between parents and children, masters and servants, sovereigns and subjects, God and man. So justice is one thing between equals and another between the governor and the governed, according to their difference in rank. The former, if I am not mistaken, may be called the law or right of equality, and the latter, the law or right of superiority. Number 4, there is another meaning of the word law, or right, different from this, but yet arising out of it, which has reference to persons. In this sense, a right is a moral quality annexed to a person, entitling him lawfully to possess some particular thing or to perform some particular act. This right belongs to a person, although it is sometimes attached to things, as servile dues are to some lands. The latter are called real rights, in comparison to others that are merely personal. Real rights versus personal rights. Not because such rights do not also belong to persons, but because they belong only to those who possess the particular quality. This moral quality, when perfect, perfected title, not legal title. This moral quality, when perfect, we call a faculty. When imperfect, an aptitude. The former corresponds to the actuality, the latter to the potentiality in natural things. Number 5, jurists call a faculty the right which a man has to his own. We shall hereafter, taking it in its strict and proper sense, call it a legal right. This right includes the power we have over ourselves, which is called liberty, and the power we have over others, like that of a father over his children and of a master over his slaves. It includes also the right of ownership over property, either absolute or incomplete, such as rights to usufruct and to hold pledges until payment is made. Also, the right of a creditor to what is due him on the other side as a debt. Number 6, legal rights, again, are of two kinds. Private, which have to do with the interests of the individual, and public, which are superior to private rights. No. Because they are the rights of the community over its members, and over the property for the common good. Hence, regal authority is above that of a father and of a master, and so the king's right over the property of his subjects for the common good is greater than that of the owners themselves. That's public. And hence, every citizen is more obliged to contribute towards the public expense than to satisfy a creditor. Number 7. Aptitude is what Aristotle calls worthiness, that is, suitability. Number 8. Legal rights are the subject of expletive justice, which is known generally as justice, properly or strictly speaking. Aristotle calls it contractual justice, contract, which is too narrow a name. For when a man who holds property that is mine returns it to me, he does it not because of a contract, yet it is an act of the same justice. Attributive justice, which Aristotle calls distributive, has to do with aptitudes. It is an accompaniment of those virtues which aim at the welfare of other men, such as generosity, compassion, foresight in government. It is not true to say, as some do, that attributive justice is concerned with public property and expletive with private. On the contrary, an individual who wishes to give a legacy from his own property is acting in accordance with attributive justice, whereas a state that returns from the public funds what some citizens have spent on a public enterprise is performing a duty of expletive justice. The distinction was correctly drawn by the teacher of Cyrus. For when Cyrus had given to a small boy a small tunic, which belonged to another boy, and to a big boy, on the other hand, a big tunic, his teacher told him, that would have been right if he had been appointed judge of what was suitable for each boy. But when the decision to be made was to which boy the tunic ought to belong, then the question to consider was which boy had the more lawful right to it, the one who had grabbed it by force or the one who had made or bought it. Number 9. There is a third meaning of the word law, which is the same as right. When law is taken in its widest sense and denotes a rule of moral action, obliging us to do what is good. We say obliging us, for the best counsels or precepts, if they lay us under no obligation to obey them, do not come under the name of law or right. Permission, strictly speaking, is not an act of law, but a negation of action, except when it forbids a person to hinder another from doing what the law permits. But as we said, the law obliges us to do what is good, not simply what is just, because law in this sense has to do with matters not only of justice, as we explained it, but of all other virtues. That which is good by law in this sense may be also broadly called just. The best division of law, understood in this way, is to be found in Aristotle, who calls one kind natural law, and the other voluntary law, or statutory, in the strict sense of the word, or sometimes positive law, statutory law, voluntary law, opposed to natural law. Number 10. Natural law is a dictate of right reason, showing the moral necessity or moral baseness of any act according to its agreement or disagreement with rational nature, and indicating that such an act is therefore either commanded or forbidden by the author of nature, God. The acts for which such a dictate exists are in themselves either obligatory or unallowable, and therefore recognized as necessarily being either commanded or forbidden by God. This mark distinguishes natural law not only from human law, but from ordained divine law, which does not command or forbid things that in themselves and by their own nature are either obligatory or unallowable, but by forbidding them makes them unallowable, or by commanding them obligatory. Now, to understand natural law, we must observe that some things are said to be a part of it not properly, but, as the schoolmen love to say, by reduction. These are things which do not conflict with natural law. As to repeat what we just said, we call things just in which there is no injustice. We must further remark that natural law has to do not only with things that exist independent of the human will, but with many things which are a result of the exercise of that will. Thus, private property, as now in use, was a creation of the human will. But once it was introduced, the law of nature tells me that it is wrong for me to seize what is yours against your will. The law of nature also is so unalterable that it cannot be changed, even by God himself. For though the power of God is measureless, things can be mentioned to which it does not extend. Yet when this is said, it is said only. It has no meaning in reality, but contains in itself a contradiction. Thus, even God cannot cause twice two not to make four. Thus, even God cannot cause twice two not to make four, nor again can he make what is intrinsically evil not evil. And this is Aristotle's meaning when he says that some things are no sooner named than we perceive their evil nature. Yet it sometimes happens that in cases coming under some rule of the law of nature, there is an appearance of change that deceives the thoughtless, whereas in reality there is no change in the law of nature, which is changeless, while in the points that come under it there may be variation. For example, if my creditor gives me a receipt for a debt I owe him, I am no longer bound to pay it, not because the law of nature has ceased to command me to pay my debts, but because what was a debt has ceased to be one. Thus, too, if God should command the killing of someone or the taking away of his property, that would not be authorizing murder or robbery, words which always imply a crime. An act performed by command of him who is the sovereign Lord of life and of all things would not be murder or robbery. There are also some things allowed by the law of nature, not absolutely, but under certain conditions. So it was natural to use these things in common, as long as private ownership had not been introduced, and to obtain one's rights by force before laws were enacted. Number 12. That anything is or is not a part of the law of nature may be proved by two kinds of argument, a priori and a posteriori. The former a more subtle method, and the latter more popular. We are using the a priori method when we show the necessary agreement or disagreement of a thing with a reasonable and social nature, the a posteriori when without absolute certainty, but yet on strong probability, we infer that a thing is part of the law of nature, which is accepted as such among all, or at least among all the more civilized nations. For a universal effect demands a universal cause, and the cause for so universal an opinion can scarcely be anything but the common sense, as it is called, of mankind. I said the more civilized nations, and not without reason, for as Porphyry well observes, some nations are so savage and inhumane that no fair judges could base a low opinion of human nature on them. Andronicus of Rhodes says, "To men of a right and sound understanding, what we call the law of nature is unchangeable, nor does it alter the cause that men of sick and perverted minds think otherwise. For he who says that honey is sweet is not lying, because it does not appear so to men diseased." 13. We have said that there is another kind of law, which is voluntary or positive law, deriving its origins from the will, and this law is either human or divine. 14. We will begin with the human, as more generally known. Human law is either civil law or else a law more or less broad in scope than civil law. Civil law is that which issues from the civil power. Civil power is that which governs a state. A state is a complete association of free men. Freemen. Check that under Black's Law Dictionary. Freemen. Combined in order to enjoy their rights and provide for their common advantage. The law that is narrower in scope and is not derived from the civil power, although subordinate to it, is varied in character, comprising the commands of parents to children, of masters to servants, and the like. The law that is broader in scope is the law of nations, which derives its forceful authority from the will of all, or at least of many nations. I added of many nations, because scarcely any law can be found common to all nations, except the law of nature, which is itself often called the law of nations. Frequently, indeed, in one part of the world there is a law of nations which does not exist in another. The proof of a law of nations is the same as that of unwritten civil law, long custom, and the testimony of the experts. For this law, as Dio Chrysostom well observes, is a work of custom and time. In the study of it, we derive great help from the eminent writers of history. Number 15. As for what voluntary divine law is, the meaning of the words clearly tell us, namely, it has its origins in the divine will. By this fact it is distinguished from natural law, which, as we said, may be called divine also. To voluntary, divine law we may apply what Anaxarchus vaguely said, that God does not will a thing because it is lawful, but that it is lawful or lawfully due because God willed it. Now this law was given either to the human race or to one people. We find 3 occasions on which it was given by God to the human race. The first, immediately after the creation of man. The second, on the restoration of mankind after the flood, and the third, on that more glorious restoration of mankind through Christ. These 3 bodies of divine law are undoubtedly binding on all men, as soon as they come to a sufficient knowledge of them. Competency. Number 16. Out of all the nations, there is one to whom God vouchsafed to give laws of a particular kind, and that was the Hebrew people, to whom Moses thus speaks in Deuteronomy 4, chapter 8, verse 8. What nation is there so great, that hath statutes and judgments so righteous, as all this law, which I set before you this day? Now it cannot be discovered by any sign that God intended any other people but the Israelites to be bound by that law. Therefore, as regards ourselves, we have no need to prove any abrogation of that law, for it could never be abrogated as touching those on whom it was never binding. Number 17. Since then the law given by Moses, as we have just shown, can impose no direct obligation on us, let us consider whether it has any other use, either in this inquiry into the law of war, or in other inquiries of the same kind. For to know this is important on many counts. In the first place, then, it is evident that the Hebrew law enjoins nothing contrary to the law of nature. For since the law of nature is permanent and unchanging, nothing contradictory to it could be commanded by God, who is never unjust. Whatever the law of Moses commanded regarding the virtues which Christ demanded of his disciples should be obeyed by Christians now, to an even greater degree. This is for the reason that the virtues of humility, patience, and charity are required of Christians in a higher measure than they were of Jews under the Hebrew law. And rightly so, because the promises of heaven are far more clearly laid before us in the gospel. Hence, the old law, when compared with the gospel, is said to have been neither perfect nor faultless. Hebrews 7:19, 8:7. And Christ is said to be the end of the law. Romans 10:4. And the law, our schoolmaster to bring us to Christ. Galatians 3:24.